You're alive.
Good morning. It is Thursday, the 24th of April. This is Senate Transportation. We are here to talk about S4, and we have Damien from our Legislative Council, and you're on, Dave.
All right. So for the record, I'm Damien Leonard from the Office of Legislative Counsel. We're back to talking about S4. And I think at the end of the last hearing, Senator Harrison had been asking questions. Had did I say? Had been asking questions about some of the potential benefits or drawbacks related to either taking more time to consider S4 and waiting on it, or moving forward with S4 now. And so following the hearing, the chair asked me to dig a little more deeply into that. Before I sort of walk through what I've brainstormed on that, are there any specific questions about the bill language that I should answer? Seeing none, I will get into it. So the way I broke this out was sort of looking at the benefits of moving S4 now before the end of the biennium, and the drawbacks of it, and then the benefits and drawbacks of waiting on S4 until next January at least. So so starting with moving it now, I want to emphasize too that with some of these benefits and drawbacks, there is both a benefit and a drawback on the same exact piece.
Yep.
So, you know, the first here is for purposes of individuals who introduced the bill and or have co-sponsored it and are supportive of the municipality's position. Clearly moving the legislation forward would signal continued support. So I've added that under as a benefit. It kind of goes without saying. And it doesn't really get to the policy issues that are potentially here. It's just a
Statement of legislative intent.
I would say it's not even that. It's just a statement of support.
To the public.
Yeah, it's a public statement. I don't think, so, you know, I think that's the first and most obvious benefit if you were a supporter of the underlying bill. The next benefit, and this one is also a potential drawback, is that on one hand, adding in this language around maintenance could provide municipalities with more certainty concerning future maintenance. On the other hand, it could also provide more uncertainty because you have pending litigation and the possibility of future litigation over this. So it's kind of like it's potentially an empty right that you're granting, or one that comes with potentially high cost. If you then move forward under the statute with maintenance, only to face a lawsuit for a taking.
Can we ask questions as we go along?
Yeah.
So I heard you say provide certainty to municipalities, but not necessarily provide certainty.
So
can I just, I'm thinking the way I'm interpreting that is, gosh, it went out of my head.
Maybe the word is reassurance rather than certainty.
But it's not real reassurance.
It's not.
It's pretend. It's not the best word, but
it's
but you might be
illusory.
You might be giving unfounded
that's the drawback that follows.
Yeah, but that's
that reassurance could be unfounded and could actually result in potential liability.
Okay, but even aside from the liability, you're telling someone that something is going to happen, or we would be implying that it's going to happen.
We would be implying that it's okay. and not, we would be implying that, yes, the legislature says you have this right. But the problem is if they didn't have the right before we granted it. So like I discussed the other day,
Right.
if the plaintiff in the case prevails, or if there were a similar takings claim, or if there were a takings claim filed in the future saying you didn't have this right before the legislature granted it, you actually could potentially create this false sense of comfort, that then could result in additional litigation, and additional costs. So it is something where it's kind of a showing of support, which could provide a sense of comfort to move forward. But then the risk I really want to flag for you, and that I think I flagged in previous testimony, is that may be a false sense of comfort.
Okay.
And if the litigation goes one way, it could actually result in potential additional liability for folks who rely on that sense of comfort and aren't following the litigation closely, or aren't familiar with the law that underlies the litigation and could underlie potential future litigation.
Okay, so false sense of comfort, that's a really important statement. And is the potential liability not just the states, but also the municipalities?
Yes, I think so.
Okay, so.
Yeah. So I think I'm not litigating these cases, but I think that it is potentially both the state and the municipality that could be facing liability here if maintenance is, if the court finds that there's no right to maintenance right now, that lies with the landowners, and then we grant that to the municipalities. I think that you then have, if you have municipalities relying on that based on, the legislation that passes, and then they get sued, and the suit could be against both parties. I think even if the court finds that the taking was committed by the state and not the municipalities still have to expend time and energy and money to defend that lawsuit, and to get themselves dismissed from it. So I think that it is something where I think, because that legal issue is out there right now, while we would be potentially providing reassurance, I think that is a false sense of reassurance, or an illusory sense of reassurance. It's kind of like saying, trying to think what, it's like if you cover up the soft spot in your floor with a rug. If you picture an old house, sorry, this is maybe not the best metaphor, but it's like, you can't see the hole that's there.
Right, but the additional liability isn't in that.
And that's, and some municipalities may be sophisticated and say, we want resolution on this. And others may say, well, I think this is the legislature saying what its intent was, we're going to move forward. And then if they end up getting sued by their landowner, they may have done, a small amount of maintenance, and that could then become very expensive maintenance, even just, getting to the point of hiring the attorney and, defending the initial stages of the lawsuit. And I can't speak for the municipalities. This is just me flagging general issues that I see here, and the general risks, because at the end of the day, whatever you decide to do, you need to move forward with your eyes open, fully informed, and then make your decision. Ultimately, the policy call is up to you. But I want to flag this because this is one of those things where I think, on the one hand, there seems to be, this would seem to be providing this sort of legislative blessing to move forward. The concern that I have is that is that you end up with a lawsuit or a claim that comes saying, well, you didn't have that right beforehand, and so that right was taken from me. and now you need compensation. And so we essentially cannot control what the law was from 1986 until now. And the way the law works here is if we gave up that bundle of rights in 1986, as is being argued in that case, and then we give it back, we have now taken property, and then the town is maybe liable for compensation plus the costs of defending and or figuring out that compensation. And we have talked about how we can try to build in protections into the bill to do that. So there is a condemnation process. The tricky thing with that is, and we do, so I should be clear that we do draft bills that relate to law that's currently being litigated. So currently we have, there's a charter, Burlington Charter, that's being considered on firearms, where the constitutionality of that is based on a Second Circuit decision that's been appealed to the US Supreme Court. So there could be an outcome there. The difficulty here is that we would have to engage in some pretty complicated drafting to try to anticipate the potential outcomes of the litigation and any unforeseen consequences. And as I mentioned the other day, the challenge here is trying to anticipate how the judge is going to rule and what the judge may or may not bring up, and then potentially having to come back in January and rush to get additional legislation out if we get clear ruling on this. Yeah.
Thank you, Chair Westman. And I understand where you're coming from with the legal perspective. I think we've kind of lost the plot a little bit with this, though. Like, I feel like we're trying to adjudicate a trial that's happening. And I think it's kind of relevant, but it's also irrelevant to me in many ways, because my goal as a lawmaker is to best facilitate what my constituents are asking for. And what I've heard from my constituents is they want access to legal trails, and they want to be able to participate in the beauty of Vermont. I've gotten just a deluge of emails on this from everybody who bikes, walks, or takes their dog out on any of our trails, our interconnected webs. And I guess I'm feeling a little bit like we've lost the plot, where we are trying to answer a lot of unknowns that unfortunately put our trails at risk of being unused, which would be such a disappointment for me, rather than, like, we're trying to answer a possible hypothetical lawsuit outcome rather than what do people actually want represented in law. And what I've heard from my constituents is they want the authority to maintain legal trails, and that the maintenance of those legal trails oftentimes determines the use. Because if you've got a big log over a trail, well, you're probably not going to be able to bike as easily as maybe a walk over the trail, walk over the log. I've also heard that the towns themselves, they want to be able to continue to be a part of the use of those trails, and that private property owners being able to just flip a switch on yay or nay totally disregards the ability of municipalities to do the work that they need to do to keep their public happy, and affects the entire network. Because if there's one bit that's cut off, that can cut off an entire ventricle of a path. So I totally hear what you're saying, and I don't think you lost the plot. I think we have unfortunately been bogged down by someone who's trying to litigate this in court, rather than what have the people of Vermont asked us to do. So I guess I hope that in this bill that we do move forward with protecting legal trails, regardless of if there is a specific lawsuit on it, I think we can cross those bridges when we get to them. If there is a conversation about compensation, I haven't heard that with the towns having to potentially compensate for use if it gets changed, like all of that feels super hypothetical and in the future, when what I'm hearing now is that there is risk of legal trails not being accessible. So that's my priority. And I respect what you're saying as well, but that's kind of where I'm at. So I guess I'm confused about where we are with the bill and if we're including it in the T-bill, and it sounds like we're not doing the maintenance section. We are doing the general allowance section with intent.
So the T-bill includes the maintenance section.
Okay.
The S4 in front of you includes maintenance and right to regulate uses, which is actually not being disputed. Both parties in the court have said that they don't dispute that. The statute states it explicitly.
Okay.
This would be,
Can I ask you a question?
Yeah.
Are you saying that enumeration of powers, that section is not forbidden? Is that what you just said?
so there's already explicit language in the statute that says that towns have the right to regulate the uses.
So then why do we need this?
I believe that was intended to add additional clarity to that. I am not the drafter of S4. But I believe that was intended to add additional clarity on that issue.
Well, if it's written twice, it could end up having confusion. And then this mentions legal trails, of which there's no definition of.
Yep.
So I don't know if we want to use legal trails and just say,
Right. So
the way it's worded here is like public right of way that is not a highway or something like that, or define legal trail.
Well, we define trail.
We define trail means the public right of way that is not a highway. So we could say that that they can regulate the use on a public right of way that's not, but they also have the right to do it on highways.
So are you done, Damien? Or-
No.
So why don't you finish and then we can move on to the.
yeah, you actually see the language on reasonably regulate uses. The existing language is in the bill. If you look at page 2, line 13 and 14, there's notes on regulating the uses, and then if I look in my notes, there's additional instances of that, and briefings for both parties in the case say that they're not disputing that. So
Say again what page, please.
2 lines 13 and 14. So
8C, is that still the right sections?
Yeah, I see
Yeah.
that as legislative bodies. Maybe that's.
a legislative body is actually what we use instead of selectmen.
So it's this
We-
pre-existing language of regular
Yeah.
uses of recreational trails, which I don't know, if recreational trails is defined, if that matters, but right.
Right.
And if you look at the statute, there's not an 8C.
It's not, so we are renumbering. If you look on line 9,
See, so it would be part of the next.
yeah, we've added a new subsection A, subsection former sub A is now sub B.
Yeah.
Former sub B is now sub C. So, getting back to the discussion, the first part here. So Senator White, you essentially brought up some of the other benefits of moving forward at this point that I had on my list. The one of them being that the General Assembly, would be enacting a statute. If assuming this conforms with your policy positions, I'm not saying that, but if you move forward, you'd be making a statement that S4 is in conformance with our policy positions. And it could provide encouragement for municipalities to continue maintenance for those that are conducting maintenance at this point. And or to begin performing maintenance if they are considering it. And it could provide some sense of confidence to them. That does go back to the point that I was making before, which is the performing that maintenance, and that sense of confidence. So performing that maintenance could pose risks to the municipalities, and that sense of confidence could be a false sense of confidence.
Because there's a lawsuit.
Because there's also, even regardless of what happens with that lawsuit, unless we get a decision in it. So, I mean, if we get a decision in it, sometime soon, that goes one way or the other and declares what the party's rights are, then we've got some clarity about this and we would know about that. I'm going to talk a little bit about how this may impact the ongoing litigation and could address that in just a moment. But even if, for example, that lawsuit were to, because that's asked for a declaratory judgment on the current law, there is a chance that what happens right now, if we pass the law, is the court says the law has changed. We're not going to issue a declaratory judgment, and so then a new lawsuit has to start on a takings issue, which then results in additional uncertainty for towns, potentially for another couple of years, as we work through that lawsuit on the takings issue. So then I think the issue that you're dealing with here is that you could be providing a sense of confidence to move forward, and then we could end up with actually being in limbo for longer.
Yeah, I don't know if I agree with that. I think I hear what you're saying. I think that's all predicated on someone else filing a lawsuit, which sure, that could happen now. It's happening now. What I'm hearing is, I don't think it's a false sense of confidence. I think it gives coverage for communities now. So they have the ability, and it also keeps those trails open. I think what's happening right now is people are saying, we are actually worried we need to back away from maintenance and upkeep of these trails because we are so worried of the outcome of this lawsuit, or because another lawsuit could always happen. There's always more lawsuits that could happen. So it feels a little bit like and I understand you're saying it could lead to more uncertainty, but there's active uncertainty right now. And so we're trying to give confidence because there should be confidence. You know, so I hear what you're saying, but I disagree with that.
Okay. So I think the issue here is that nothing we do today in S4 is going to change the law that was enacted in 1986 and that was in place from 1986 until present. So you may be giving confidence moving forward. You may also be opening up potential liability. And if that is the position that
That's my
you choose to take, then that's okay. That's why you're an elected official and I'm not. And that's, you know, you serve your constituents, and that's definitely, you know, something that you can choose to move forward on or not. My job is to highlight the potential risks for you. And it's the potential risk that I see here is there are a couple of things that we'll just turn to the litigation now. So what you have is the case is basically asks the court to declare what the law is. Core function of the courts, interpreting the law. one of the potential outcomes here is that the parties, so we have one VSA 213 and 214 that say our legislation doesn't affect pending lawsuits. That said, there is a chance that the outcome gets delayed as the parties argue over what the impact of this is. Does it render the claim moot? Does it make it so that a declaratory judgment is inappropriate at this point because the law has changed? And so then the question is, it's actually, a different suit for taking. So you could get an answer that could delay your answer in the current court case. And it could also mean that instead of having an answer on the issue of what's the potential exposure prior to when you change the law, if you do that, the question is, do we have any exposure for conducting the maintenance that the legislature has said we can conduct? If a takings claim is filed because the argument being that we didn't have that right before. And so what happens then is the potential is that there continues to be uncertainty going forward, and that the question right now of being afraid to take action may be temporarily addressed until the next lawsuit is filed, and then everyone will be afraid to take action again. And I can't say what the municipalities are going to do, but you can then you could essentially be just moving the uncertainty further down the road, because then, if and again, I can't speak for the municipalities here. I'm in an awkward position here because I'm a neutral third party. I'm not involved, but you do run this risk of now, so town A, maybe this current lawsuit goes away. The court says the law has changed. I'm not going to issue a declaratory judgment on a law that no longer exists. And then the maintenance begins, and whether it's the current plaintiffs or a different landowner, they say, we saw that case, we were following it closely. We don't think our town had this right before them. And we've talked to counsel who thinks we have a pretty viable takings claim for compensation from the town. We're now going to sue our town for a taking and for compensation. And then again, we're in court again, going through starting back from square one on this. And now the town's around. I mean, as a town, you can say, we don't think it's a strong claim, we're going to move forward. Or you can say, I have a limited budget. I'm going to spend it on class 4 roads where I'm very comfortable with my rights, and let them figure this out. And so I'm going to take the time to wait for this current litigation. And we are running into a really strange period, because we're coming up on the time of year when you maintain trails, summer, fall, and as soon as the mud dries, that's the time. On the other hand, it may be that you're either way you move forward on this, the maintenance season is potentially in jeopardy anyway.
Go ahead.
So I now understand fully what you're trying to say, which is there's the possibility that if we change the law, that then there could be someone who brings a court case who says previous maintenance was bad because you changed the law. I disagree with that. I think that that's an inaccurate reading of the law now, and I hope a judge would decide that now. Obviously not a judge, so can't say that. If I were a judge, I would probably say that this was moot. Would be how I would read it if we changed the law. But why does clarifying the law, saying this is what we want, going to make it that there's liability for previous action? I don't understand that. Like, we change the law all the time, and then we say, no one can go back and say, I'm gonna sue you because you clarified the law, so I think it was unclear, therefore wrong. Like, that doesn't,
So the,
not
the
making sense.
question is whether it's a clarification,
I think it's a clarification.
and I hear that. I hear you loud and clear, Senator. The question, though, from the court's perspective is, was this a clarification? So this right existed, and they're just enumerating it more clearly.
Yeah.
Obviously, that is the municipality's position on what S4 would be doing. The landowner's position would be this right didn't exist, and the legislature saw that and affirmatively granted this right, which previously laid with me and was part of my property right. And under both the Vermont and US constitutions, you can't take one of those property rights without paying for it and compensating the landowner for it. So that's the liability.
But we've been operating in a world before this lawsuit where everyone believed, to my understanding, that that's what it was. So the only reason we're having this discussion is one particular landowner says, I disagree with how the clarity of the law frames it. And what I'm saying is, I think this does clarify it to be crystal clear to build that confidence, but I don't think it changes the right. I disagree with that. So I would, yeah. So I hear what you're saying. I think we're in this situation because unfortunately we have a lawsuit that was brought to clarify a law that I think was very clear, and I want to make it so clear that that's what we want. I don't think that's changing the right. You know, and I would be so sad if we don't move this, and then I hear from my bikers and my walkers and they say suddenly we can't access trails anymore. That would be such a loss for our communities. So I want them to have the confidence. And I think, in fact, we lower the risk of them having to compensate landowners by doing this versus increasing the risk of that happening. Because they can still sue. And if we did or didn't do this and the lawsuit went the other way, they then still could be suing their towns for anything 1980, you know, for that period of time, correct? Like, you could still, if the lawsuit.
If the court decides that the towns had this law all along, there is no property right that the landowners can claim in preventing the maintenance.
Yes, but if the lawsuit went the other way,
If the lawsuit goes the other way,
then they would
And
be
they-
sued.
hold on a sec. So, and this, you're helping me segue to the question of what are the benefits and drawbacks of waiting. So let's say that the committee waits to take action until next session, so January, something like that, and waits to see what the court says. In the event that the court rules for the landowner and finds that municipalities don't currently have this right, we have a process already in statute for what happens when you decide you need to lay out a road, or you need to lay out a utility line and it crosses someone's private property. So there is a process for condemnation, and it's a process that is designed to make sure that landowners get fairly compensated. It also, because you have to pay compensation and make a showing of necessity, et cetera, as part of that process, it also prevents the municipality or the other entity acting on behalf of the public from just taking land willy-nilly. And so in the event that the court were to rule for the landowners, what we would be back here doing, assuming it was the pleasure of this body to advance something that provided this right to maintenance, or at least the ability to gain this right to maintenance. Again, this is assuming that the court rules in favor of the landowners. We would be back here basically establishing what the process is to grant that right, to ensure that your municipalities and your constituents can maintain these trails and can open them up for the uses that you're looking at. And we would look at questions like, are there limits that we want to put on the maintenance they can do? Are there reasonable restrictions that we want to have? Is there a certain showing that we want to require them to make? And so that would be the discussion we're having then. The alternative is if the court rules in favor of the municipality. So if we assume that the court rules in favor of the municipality, what we'd be back here doing in January is, well, one, asking, is legislation necessary? And assuming that you decide that it is, the second thing we'd be looking at really is how do we make sure this law is crystal clear for everyone? Because what got us here is ambiguity and silence in the statute. And so at that point, the bill, and we've done this before, when courts have addressed ambiguous questions of law, we've said, in light of the ruling in, this case, we find that the court's ruling is consistent with our interpretation of the intent, and it is our intent in this bill to codify that ruling into law. So we're not, and this is important because courts assume, and I'm not commenting on the arguments of the parties in the case because I know they have argued about this issue, but courts assume that when a legislature adds words or takes them away, that it is intending to change the law, unless you say this is a clarification. So we do that with our technical corrections bill. We say right at the beginning, this is not intended to change the substance of the law, and any substantive change to these sections will prevail over anything in here. These are just technical corrections. And so we would very clearly say at the beginning, it is our intent to codify and clarify the law based on the ruling in X case. And then we would go through and clarify things. And if there are questions about, again, like Senator Perchlik raised the other day, well, what's the limit of maintenance? And when does that go too far? You would then be clarifying based on that. So it really, this is the first benefit of on the other option here that you have before you. And this is just assuming that you move S4. There's always the third option of, leave it on the wall and don't move it forward. But assuming you wait to move it forward, the first benefit, and really the most clear benefit, is that you potentially, there's no 100% guarantee that the court finishes ruling and that the case is fully resolved, but you potentially have clarity on this body of law or additional clarity, and then you can craft the legislation and tailor it to the clarity that's provided. And so that allows you to avoid also the potential for unforeseen nuances in the court's decision. So if we move forward now, I can never guarantee exactly where the court's going to come down, and none of us can predict that. It'd be great to be able to jump into a judge's head and know what's coming. But, we've even seen with the US Supreme Court, when those decisions have gotten leaked in recent years, the final decision is often slightly different from what's leaked. And it's important to know this is an ongoing iterative thought process there. And even the parties to litigation likely can't predict everything about the decision. Maybe they get it right, but there's also that chance that the judge grabs on to something different. In January, in an ideal world, the court's issued a decision. We have some clarity. Maybe the municipalities have already gotten clarity that they can maintain, and we're just clarifying the law. Maybe they've been told, no, you don't have that right. And now we're working on how do we grant them that right? And how do we make the process work so that it's not going to put them back in court? So that's really the biggest benefit of waiting.
I just asked, it sounds like regardless of what we do, we're going to be back to our position, probably.
Holds the court.
So I would say that there is a reasonable likelihood that regardless of what we do, we'll be back here to either make sure everything is in line or to make corrections if we move forward now. or we'll be back here to move the bill forward in light of the court's ruling. So this is there. This is really a question of, so the difference between this and, for example, the firearms bill, is that if the Supreme Court overturns the Second Circuit ruling that they're relying on for the charter amendment for Burlington, the charter amendment just becomes unenforceable. The difference here is that, if folks move forward, and then there's a takings claim that prevails, they actually have to pay compensation for that. So there's damages that come out at the end of the day. And so we are in a somewhat different scenario. It's not, a bar to you moving forward. If we were barred by moving forward by litigation every time, then the legislature would be powerless. But it is something that you need to take into account. Obviously, there are very strong arguments that you're hearing from a number of your constituents on why this bill is important to them and why they think you should move forward right now. And it's not my place to, look at those arguments and say, yes, this is a good argument, this is not a good argument, something like that. It's just my place to identify the potential legal issues that are coming up and to, kind of identify that we're in a state of, in a place of uncertainty right now.
Yeah.
And moving forward with the legislation right now doesn't necessarily eliminate that uncertainty. It provides a clear statement of intent, but it doesn't necessarily get us to a point where the municipalities have clear path forward. That's, I can't speak for them, but I think my analysis of the law is that there are still legal risks and pitfalls for them.
Sure.
That move forward.
And
Either way.
I think what I've heard from my town is those feel like lower risks than the absence of us doing something. So for me, that is what's the most compelling point is I'm hearing from my towns in the absence of us doing this, the uncertainty and the risk is much greater than if we do something. So that's kind of where I'm coming from because I want to be able to go biking on trails this summer. And I want them to be safe and I want them to be accessible to every Vermonter. So we could be making a decision today to not move forward with this and forcing towns to continue to live in greater uncertainty and choosing then not to maintain their trails for a summer. And one spring maintenance can have a cascading effect. What I've heard from my towns is that they are comfortable with assuming the risk potentially of if there is a change in the court side, but I think the risk. So I
Something you said.
Uh,
Yeah, would you?
I think we're going to take a 5-minute break.
Sounds good.